Now back to the show. This is The Law Show on CL 650.
It don't matter where you've been. Welcome, stranger. Come on in.
Yeah, we're talking about immigration law and the border specifically. Gordon Maynard and Alex Stojkovic on The Law Show, our guests from MKS Law in downtown Vancouver. So at the border, the enforcement issues if you misrepresent yourself, if that's just in any case, whether you're a Canadian citizen or permanent resident or somebody visiting the country, what can happen? Or what kind of things do people misrepresent themselves? Well, pretty much anything, I would think.
I'm going to tackle the first part, which you said with Canadian citizens. If a Canadian citizen misrepresents their something to do with their customs declaration or something along those lines, there's punishment under the Customs and Excise Act that may apply to them, or the Proceeds of Crime Money Laundering Act, or the passport order, various things like that. And they could actually face criminal prosecution. In the case of permanent residents or foreign nationals, though, there's actual sanction, admissibility sanctions under the Immigration and Refugee Protection Act that I'll let Gordon
So they can lose their status. Mm-hmm. Yeah. So anybody.
Which is what we were referring to earlier in the show.
That's right.
It's like, that's that, you know, you can be thrown out.
That's right. Or denied entry.
Yeah.
So one of the grounds of inadmissibility is misrepresentation. And that came about specifically in the 2002 revision of the Immigration Act. The overseas officers in particular were really choked about the fact that if they had somebody applying to come to Canada and that person made a misrepresentation in their application, let's take a simple example. They said, I'm going to come to Canada, I'm going to bring my 3 kids. Only one of them wasn't their kid. One of them was their brother's kid. And they were just trying to use false documents to bring that child to Canada. If they got caught out, they would have their application refused. But there would be no other consequences. They were free to apply again and tell the truth this time. And then you wouldn't have a grounds to refuse them. So officers wanted misrepresentation to have consequences. So they rewrote the act, and they made misrepresentation a particular ground of inadmissibility. And it's a ground of inadmissibility that allows an application to be denied. If you are found to have committed misrepresentation, there was a 2-year bar against future entry into Canada. That's now been changed to a 5-year bar. All right, so it impairs you from entering Canada for 5 years. And it also applies to people inside of Canada. So if you're already an immigrant in Canada, and you either made a misrepresentation in your original application, or now you make a misrepresentation in your sponsorship of your mother, or sponsorship of your spouse, misrepresentation as to your residency in Canada, these are all grounds to get a removal order that cause you to lose your status and bar you from Canada.
So I would guess a lot of people would be on board with this because you're blatantly trying to withhold something to get the advantage of coming to the country.
Well, it's true, but there's a lot of unintended consequences to this. So one of the big misrepresentation areas has to do with your requirement to truthfully lay out all of the children that you have, including ones that perhaps your current spouse doesn't know about.
So that's embarrassing when you're filling out the form.
Certainly is. Certainly is. And it is not an uncommon problem in Vancouver that somebody who has a child from a previous relationship later tries to sponsor that child and is barred from doing so because they didn't disclose them initially and misrepresented the existence of that child. And the consequence there isn't just a question of the sponsor facing misrepresentation proceeding, but the child is no longer a family class member. So the child can't be sponsored anymore. They don't.
Could it not be argued that he didn't know that this child was his?
That's often argued. Yeah. But unfortunately, the way our law is worded, that may not be a defense in many people's cases.
You don't have to have intent to misrepresent. It's just a question of fact. Did you say the truth or did you not? It's not a question of whether you thought it was the truth.
So there's a well-known case that was one among the first to set the bar for this. And in that case, the wife filled in a form incorrectly that her husband had not been married before. Well, in fact, he had been married before. He hadn't disclosed it. To her. And although she thought she was truthfully answering, that didn't matter because the husband had misrepresented that he'd been previously married. And this went to the heart of his own application. And she, as his dependent, was found inadmissible just as he was.
A similar situation would be a child who comes to Canada with their parent, and the parent commits misrepresentation in the parent's application, but the child, the accompanying dependent, has no knowledge of that. No
and
knowledge.
how would they ever?
It depends on their age and depends
Yeah.
what forms they were required to fill out. They may never been required to answer that question. They may not have had the facts in their mind anyways. But once the parent is found to have committed misrepresentation, then they are told that you too have committed misrepresentation indirectly. That's the way the law is interpreted right now, and it's a very interesting issue.
Either directly or anything that either directly or indirectly could adduce an error in the administration of the act.
So how can you write a law that's going to capture all of these what ifs?
Well, that's pretty wide.
Well, they
right?
did.
Indirectly or indirectly. So whether you knew about it or not, the fact that the incorrect information was put forward is enough to get you caught.
Yeah, but I mean, this child comes to Canada with parents, and they've misrepresented their way into the country. But this kid might be 28 when this is
Yep.
found out,
Yep.
and
Yeah.
has to be sent back as well. Is there no leniency to say, well, the kid's been
There
here
can be.
for 20 years?
That's where the value of the appeal division comes in. Remember, we talked about permanent residents facing removal.
Yeah.
If they get a removal order on any ground of inadmissibility, they have a right of appeal. And at that right of appeal, you can say either that the removal order was an error in law, or you can say, no, there was nothing wrong with the removal order. We agree it should have been issued. But in all the circumstances of the case, there are humanitarian and compassion
right.
factors which justify you saying, let's not execute this removal order against
because-
this individual.
Well, the 8-year-old comes here. This comes out 20 years later. He's 28 years old. He's lived his
Yes.
whole life in
Sure.
Canada for the most part.
Right.
Why should he be sent back to another
Right.
country?
So that's the value of having that discretion.
Right.
All right. But maybe also it was a legal issue. Maybe that's not what Parliament intended by indirect misrepresentation. There's a whole line of argument supported by evidence of the government guidelines that what they meant by indirect misrepresentation was when, for instance, your consultant gets a criminal record that shows that you're clear. No, that's a bad example. Your consultant puts in a school record which says that you completed grade 12 and really you didn't.
Mm-hmm.
And you didn't know the consultant put that in. Well, you have to wear that inadmissibility anyways. They call that an indirect misrepresentation as well.
Right.
All right. Because it was part of your application. It reflected on you. What they've done is translate that to say a parent's misrepresentation, whether it's direct or indirect, also reflects on their child.
What about with the last minutes we have here, the family class, misrepresenting the family class? And we touched on that a bit now, right?
Right.
Well, with the family class, the big issues to do with misrepresentation really often are to the existence of family or not, disclosure and that kind of thing, especially when the person did or didn't disclose existence of prior relationships, or shows up at the port of entry and their document says they've never been married, and all of a sudden, when asked, are you married? Yeah, I got married yesterday. In between the time the visa was issued and the time they arrived at the port of entry.
Mm-hmm.
That sort of issue comes up.
That's non-compliance more than misrep.
It's true, yes.
The most common misrep has to do with marriages where immigration says, we don't think this is a genuine marriage. It's not just whether or not it's a genuine marriage, it's whether it was a genuine marriage or a marriage that was entered into primarily to obtain immigration purposes.
Mm-hmm. It's like the movie Green Card, right?
That's
Exactly.
Right. Yeah.
That's where it's really common.
Though we're all dating ourselves with that film, but yes.
Well, it's Gerard Depardieu, right? Isn't that who was in it?
Yeah, he looked a lot better then than he does now.
Okay, with our final time here, so talking about the border and enforcement issues at the border, what's your final piece of advice?
Oh boy.
Well, I mean,
Pick one or two.
you know, the consequences of being dishonest and being caught misrepresenting are now really, really high. And as a result, it pays to be prepared as early as possible before you come to Canada.
And that's where you would come in.
That's
You
right.
would say to them, listen, all cards on the table.
That's right. That's right. Because we can't help people unless they tell us what, you know, their concerns are.
And the
what
other
could be
thing
an issue.
I find is that once you become a permanent resident, then transfer to Canadian citizenship. Because once you're Canadian citizenship, a lot of these things go away, right?
That's correct. yes.
No, they can go back.
Oh, they can.
Well,
Yes, they can. If you obtained your permanent residence, for instance, through misrepresentation,
Yeah.
they can go back on that.
they can, although it's a much more serious level of misrepresentation.
Just the fact that you didn't divulge you were married a previous time.
That may not be enough. That's
Right,
correct.
But
However,
criminality, for instance?
criminality,
Absolutely.
that could be definitely, or your identity. If you said you were A and you turn out to be B, and they find out that you're somebody else, that, having citizenship isn't going to help you.
Yeah, bottom line, I think, is there's pretty much no statute of limitations on inadmissibilities, right? I mean, once you're guilty of an inadmissibility, it's there and it can be brought against you, whether it's 2 minutes from now or 20 years from now. And it's just going to be there. You have to deal with it.
Well, fascinating again. Thank you, gentlemen. Gordon Maynard and Alex Stojkovic from MKS Law in downtown Vancouver. I appreciate your time and your expertise, and we'll have you back again. Thank you very much.
Thank you, Zach.
And
Thank you, Zach.
that's all the time we have for The Law Show. Hopefully you learned something. I certainly did. A whole lot more. We're just peeling the onion back. We've got more layers to go. And we'll continue that conversation on a future show. It's The Law Show on CL 650.